There you go.
Back on the record. It's cause 659-538 Texas versus Lee Flores. This is a motion to enter adjudication of guilt and revoke community supervision. Representing Ms. Flores is Mr. Marshall White. Representing the Bexar County Criminal District Attorney's Office is Assistant Criminal District Attorney Eddie Villarreal. And representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. Ms. Flores and Mr. White. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Ms. Flores and Mr. White's signature on it. In fact, Ms. Flores, is this your signature on this document, ma'am? And your microphone is turned off, ma'am. Can you turn your microphone on, Ms. Flores?
Yes, there's my signature.
Thank you, ma'am. And Mr. White, as attorney for Ms. Flores, is this also your signature on this document?
It is, Judge.
Thank you. The next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal, unquote. Is this your signature on this document also, Ms. Flores?
Yes, Judge.
And Mr. White, as attorney for Ms. Flores, is this also your signature on this document?
It is, Judge.
Once again, this is cause 659-538, State of Texas versus Lee Yvette Flores. This is a motion to enter adjudication of guilt and revoke community supervision. Mr. White, it is my understanding that this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, Judge, with the condition on agreed recommendation.
Gotcha. Ms. Flores, on the motion to enter adjudication of guilt and revoke community supervision in cause number 659-538, how do you plead, ma'am?
Guilty.
Normally it would be true or not true, or true with an explanation or not true with an explanation, that sort of thing, ma'am.
Oh,
Judge, if I may, I think Ms. Flores intends to plead true with an explanation.
Fair enough. Yes. Is that correct, Ms. Flores?
yes, Judge.
Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Ms. Flores' probation?
Yes, Your Honor. Ms. Flores has performed poorly on probation and that she only reported on 2 occasions. We have not received any payments. She has a balance of $1,635 and is delinquent $581.40. We have no record of any of her 48 hours community service having been completed. She did complete the victim impact panel, but we have no proof of enrollment or completion of DWI education, drug offender education, or the CATSNP programs. The court did place her on Smart Start Mobile. She has been in lockout and had 65 skip tests at the time that the motion to revoke was filed. This is her first violation report, first MTR, and she does have 1 prior arrest for felony hindering of apprehension. And her officer is recommending revocation.
I see conditions on the motion to enter adjudication of guilt and revoke community supervision that talk about failure to submit to drug testing.
Oh, I apologize, Judge. She had the failure to submit as well on 2 occasions. I'm sorry, 3 occasions.
Okay. Mr. White, go ahead.
Yes, Judge, as I was indicating off the record, what Ms. Gross just went over should not have even been necessary. It's almost like a smear campaign. But at any rate, Ms. Flores just went on probation in September, Your Honor, which is a short 4 months ago. And in fact that she got arrested for something doesn't mean anything. That shouldn't even be anywhere on anything. There's been no adjudication about a prior arrest of that sort. Like I said before, it's a smear campaign. But Ms. Flores, Judge, was put on deferred adjudication. She made a mistake and got a DWI. She was put on deferred adjudication on a lesser charge of obstruction. She's had some financial difficulties like a lot of folks have in this COVID pandemic time period. which has caused her not to be able to comply completely with probation completely. By the way, along with the skip test, she has a number of past tests, which wasn't highlighted by Ms. Gross. So, the thing about it is, Mr. Villarreal and I agreed to a recommendation to the court that she be continued as is on her deferred adjudication, and that her conditions be modified to put her on scram. And he may have another condition, but I think that was the gravamen of our discussion, is that she would be put on scram to take her off this Smart Start mobile device. But nevertheless, still complying with the whole notion of not using alcohol while she's on probation. Ms. Flores has 2 young boys, Judge. She has a 9-year-old and an 11-year-old. Okay, again, she has no real criminal history. She got once arrested before. And, she wants to do the probation. She wants to do the right thing. She has tried. Okay, these other violations about the money, that goes right to what I was just saying about her financial difficulties. And her obviously the lockout, paying for the device. So, Judge, this is why I was saying what I was saying before we went on the record, that this matter could have been resolved by just withdrawing the motion and continuing her as we had agreed, as she had agreed to with the state. So that's what I would ask the court to do, is deny the motion to adjudicate, okay, and go along with the recommendation that we've agreed to.
Okay, let me ask you this, Mr. White. I'm looking at 3 failure to UAs. Is there a reason for any of those?
I'm sorry, Judge?
In other words, the allegations in condition number 2, for the record, I'm going to call them 2A, 2B, and 2C. And they all allege that Ms. Flores failed to submit to drug testing, the first one on October 6, 2021, the second on November 2nd, 2021, and the third on December 1st, 2021. Is there any?
I'm obviously, I'm not Ms. Flores, so I don't know every inch of all the details, but this is what I would say. I think Ms. Flores' financial difficulties, along with the burden that she obviously has as a mother to take care of her children, render her not able to function at the highest level to get everything she needs to get done. Everything, not, completely just fall apart, but get everything done that she needs to get done on probation wasn't possible. But that doesn't mean that in spirit that she does not want to do this probation, because she does. And I think she's indicated it to some extent that she does want to do this probation. Again, we're talking September. By the way, she's going to be on probation until, I believe, January of 2023. So she's got a lot of time to comply with all this money, the community service, and so forth. Now, she may be a little bit behind now, but it doesn't mean she's defaulted. She may be delinquent, doesn't mean she's defaulted. So she can get this done.
All right, you represented earlier that she was willing to volunteer to get a scram device, and then you talked about her financial difficulty. I don't see her able to afford a scram device at $350 a month. She's having financial difficulty with a Smart Start mobile at $95 a month.
Well, she's indicated to me that she has a plan on getting all her financial situation straightened out. Now, you may want to ask her about exactly what the details are on that, but she's indicated to me she has a plan on getting her financial difficulty straightened out.
Ms. Flores, please mute your microphone.
Well, she can't unmute it.
Talk right now. I agree, Marshall. She's got to talk right now. Hey, Ms. Flores, what's going on with monies? Because apparently you've been having a difficult time.
Yes.
You want a Smart Start mobile, and the scram is 3 times as expensive.
Yes, sir. I'm a single mother, as Mr. White was saying. So as well as helping my mom with her diabetic stuff. But I do plan on getting a job as soon as I'm able to get out, a full-time job at that, and be able to keep up with my payments that I need to pay, as well as I have income tax to file. So I'll use that as well to pay for some of the things to be able to catch up with my probation, sir.
State recommendation, please.
Your Honor, the state recommends weekly UAs, scram, and substantial compliance within 30 days.
And Judge, the original fine, I'm sorry, I forgot to let you know, it was $850.
Okay. Ms. Flores, in cause 659-538, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation I adjudicate you guilty of the offense of obstruction of a passageway, roadway, or waterway. I sentence you to 6 months in the Bear County Jail, assess a $2,000 fine plus court cost, credit for time served, time and money to run concurrent. I show her to have at least 16 days of time served. My understanding is the sheriff is giving 3 for 1, but I'm not the sheriff and I don't know what the current ratio is. Anything further from the state or the defense on Mrs. Flores?
Nothing from the state, Judge.
Yes, Judge, I'll just note my objection to your ruling. Again, off the record, we had a recommendation. The state should have withdrawn this motion, and Ms. Flores should not be subjected to any obviously the ruling that you just handed down to her to keep her in jail for 6 months. This was a mistake on Mr. Villarreal's part not to withdraw the motion.
Mr. Villarreal, you want to respond to that?
No, Judge.
Okay. My understanding was we made it clear on the record earlier that Mr. Villarreal was not going to make a motion to withdraw the motion to revoke, the motion to enter adjudication of guilt and revoke community supervision. Is my memory correct, Mr. Villarreal? The state's intention was never to withdraw the motion to enter adjudication of guilt and revoke community supervision in cause 659-538 on Miss Lee Yvette Flores.
That's right, Judge. There was never an intention to withdraw the agreement. That the recommendation that I made was just that, and we understood that there was no set agreement. It was just a recommendation. That's what the state recommended.
I think the point is being missed about what I'm saying, Judge. The point is being missed about what I'm saying. You just weighed in on this matter very heavy-handedly, I might add. This woman has no criminal history, and you just gave her 6 months in jail. I think, frankly, I'm not even sure why. She's been on probation for four months, roughly speaking. You just gave her 6 months in jail. That's very heavy-handed, even though the state has recommended that she be continued on probation. It's out of control almost.
Okay, noted for the record and for appellate purposes. Anything further from the state or the defense on Miss?
No, Your Honor. Have a good
Judge,
day.
if I may,
Gross, please.
Ms. Flores, I will be doing a Smart Start removal order. So if you have a family member or something that can take that back to Smart Start next week, that way you won't be charged with having to purchase the entire unit. Okay?
Yes, ma'am.
Okay.